Hi, I'd like to talk to you today about the Second Amendment and what it means for Americans today, using some historical context of cases involving the Second Amendment uh, from the last couple hundred years. Now, the Second Amendment is stated, quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The first case I'd like to talk to you about is the U.S. v. Cruikshank from 1875. And in this case, the Supreme Court ruled that the Second Amendment was solely to restrict the powers of the national government. Presser v. Illinois in 1886 ruled much the same way, that the sole responsibility of the Second Amendment is to limit the powers of Congress and the national government, but not the states. In 1939, the U.S. v. Miller took a collective rights approach and stated that the Founding Fathers intended for the Second Amendment to ensure the effectiveness of militias, and they defined militias as, quote, "civilians primarily and soldiers on occasion," end quote, and stipulated that the arms would be supplied by these citizen soldiers rather than an arms depository. This is important because it goes with collective rights, which state that the Second Amendment is meant to protect us collectively and ensure that we don't have the tyrannical oppression that our founding fathers had with Great Britain. But it also kind of leans towards the individual rights and stating that the arms that are supposed to be provided by the citizens would need to already be in their possession in order for them to have them, because obviously if you have a government that's, got it in for you, they're not going to let you have your guns. The next case I'd like to talk to you about is the District of Columbia v. Heller in 2008, and they ruled that the Second Amendment established individual rights for the citizens to possess arms and for self-defense. And this was about the gun ban in D.C., and there was also a stipulation in the gun ban that says that if you did have a firearm, that it had to have a trigger lock on it or be disassembled. And the Supreme Court also struck that down, saying that if you have an inoperable weapon to protect your home, it's not very good self-defense. So both of those were overturned by the Supreme Court. And the last case I'd like to talk to you about today is McDonald v. Chicago, and that was in 2010. And they took a different approach to striking down a gun ban in Chicago. And the approach that they took was one, they said, based on the 14th Amendment, that their gun ban was unconstitutional. And the 14th Amendment states, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States," end quote. So basically the court ruled that this gun ban, because of the Second Amendment, was unconstitutional from the state of Chicago, or from the city of Chicago, rather, because it infringed upon their 14th Amendment rights. So it's kind of interesting the way that they look at some of these things. And I would like to mention one more thing before I sign off here that I found rather interesting. There is a quote from Thomas Jefferson in which he stated, quote, "The beauty of the Second Amendment is that it will not be needed until they try to take it," end quote. And that's an interesting little tidbit from one of the people who was there when this document was put into place, and who had, I'm sure, a great deal of impact on what actually went into this document. So it's just something to think about when we think about the Second Amendment and the major debate that's going on today. Thank you.